The West Australian Law Society has raised concerns over an extension of the President's powers in the Children's Court. They warn it would interfere with the judicial process and be unconstitutional. The state government has prioritised the legislation for this week's resumption of Parliament. Joining me now is the President of the WA Law Society, Rebecca Lee. Rebecca Lee, thank you so much for your time. What's brought on this amendment to the bill?
It's hard to say what has brought on the amendment to the bill at this point in time. The government has not made it clear as to the reasons why it is, they say, urgent. We see no urgency for it whatsoever.
But it does follow a legal fight last year between the Children's Court President and a veteran magistrate. What's the ultimate purpose of changing these rules?
The government has advised that it just wants to assist the President administer the court, and that intent, there is no issue with that intent. The Law Society is concerned that the impact of the wording of the legislation goes much further than mere administration of the court and does potentially erode judicial independence.
Yeah, why do you say this amendment is so problematic? Could a Children's Court President demote a magistrate simply because they didn't like them?
Indeed, and that is the problem. It is so open-ended, the wording of this. In fact, the express wording of the draft bill is that the President has the absolute discretion to make a decision that somebody who's been commissioned to work in the Children's Court can no longer work in the Children's Court. In fact, the bill also uses the word if the President considers it not desirable for an individual to work in the court. So it's the very fact that the decision is not reviewable and is not subject to any scrutiny of any kind that is the cause of the Law Society's concerns in this regard.
Yeah, you mentioned earlier that the WA government says this is about administrative powers and managing the workload of courts, and they've said that the Law Society's concerns about judicial independence are entirely without merit.
Well, with respect, that's incorrect, and one only has to look at the actual wording used in the bill, where it talks about all the President has to do is give a notice if he thinks a certain individual is undesirable or non-desirable that they work in the court anymore. It is entirely in his or her absolute discretion to stop them working in the court. And that means that even if the state has decided that an individual has the expertise to work in the criminal matters and the care matters that the Children's Court engages in, should the President simply take a dislike or that person's not making decisions the way the President wants, that the President can simply issue a notice and they no longer work in the Children's Court. With respect, the Parliament should not be delegating the power to remove a commission effectively to one individual.
Would this bill likely have any impact on the alleged offenders who appear before the Children's Court?
It depends on what the President, whoever is holding that position at a particular time, decides. So that, for example, if a President decides that there should be no prison terms for any offender, then it might be that magistrates, not wanting to simply be removed from the job, start complying with that. It might mean that the state then appeals those decisions and it makes the whole process much more drawn out for offenders and may affect the community more broadly.
Are there any other jurisdictions in Australia where a Children's Court President can expel a magistrate?
I'm not aware of any, and it is an extraordinary provision.
Yeah, and you've also suggested that there could be a constitutional element to this.
Indeed, I think the Parliament of Western Australia needs to be aware that should they pass this legislation, it is open to attack and it's not going to assist with having this legislation the subject of litigation in courts as to its constitutionality.
Labor has an overwhelming majority in the WA Parliament. Do you think that could lead to less scrutiny of, say, bills like this?
And that is a problem we now have in this state. For some reason, this bill was not put out for public consultation in the normal course, in which case the language that is used and the impact of the language that's used could have been picked up earlier. It is simply being put through, and because of the numbers the government has in the Legislative Council, it may not get the proper scrutiny it requires.
Rebecca Lee, thank you so much for your time.
I appreciate it. Thank you.